Thank you for listening to Lone Star Community Radio. This program was broadcasted and recorded live from the LSCR studios in downtown Conroe, Texas. Lone Star Community Radio is supported by listeners like you. Donate and sponsor today. For more information on getting involved with Lone Star Community Radio, contact us at lscrstudios@gmail.com or visit us online at www.irlonestar.com.
Texas, and the Legal Connection Show is a public service legal show to answer your questions and any issues that may come up that we might be able to cover. The show airs on Tuesdays at noon for an hour every week. If you miss the show and you want to listen to a rebroadcast, you can get us on irlonestar.com. Go to Legal Connection Show. You can also go to our YouTube or Facebook by putting in the Legal Connection Show. Today is the fourth part of a four-part series on Roe v. Wade, and it's the final installment of this section. And basically, if you're not familiar with Roe v. Wade, it was a case that involved whether or not abortion the laws in Texas were legal to allow people to prevent people to be able to get abortions, or women. And it's about 50 years old. Recently, a case was granted a petition for writ of certiorari under Dobbs v. Jackson Women's Health Organization. And this particular case opinion was leaked to the press under, I think it was Politico, about a month ago, maybe a little bit less. And it has not been issued by the U.S. Supreme Court yet, but it probably will be. And it effectively overturns Roe v. Wade with regard to whether or not it is the laws in Texas or the laws are unconstitutional. The particular case that they took was a law in Mississippi. It is a little bit less stringent than the one in Texas, but the reasoning is similar. And in a nutshell, this case, the Supreme Court decision by Judge Alito, basically says that it's up to the states to decide, and it's not a constitutional issue. But I will let you make that decision. What I'm going to do today is just read the actual case, because most people don't get the opportunity to actually read the words in the opinion. They just hear in the news what's going on, and everything is kind of hearsay or conjecture. Or conjecture. I believe that you will probably agree with me that this is a very well-reasoned opinion by Judge Alito. After reading it, it basically says that the Roe v. Wade was never really written from the purview of whether or not it was constitutional or not. It was legal gymnastics get to an end. And here I'm going to start where I left off, pretty much just reading the opinion to you. I think it's extremely well written, and it'll give you some insight as to the legal reasoning behind this. All right, so here we go. Without going back to the very beginning of this case, again, the draft was released. It was circulated by Justice Alito, released about February 10, 2022, and this has not been released by the U.S. Supreme Court yet. But here's the reason behind what is likely going to be released and will be the new law. I'm going to start at page 8. You can catch the other shows if you want to go before that, or you can pull up Dobbs v. Jackson Women's Health Organization and go to Politico to read the actual released opinion yourself. But if you're just driving along or want to listen to this while you're doing some other things, here you go. The Supreme Court says, we begin by considering the critical question whether the Constitution, properly understood, confers a right to obtain an abortion. Skipping over that question, the controlling opinion in Casey, which was a 2007 Supreme Court case related to abortion, reaffirmed Roe's central holding based solely on the doctrine of stare decisis. But, as we'll explain, proper application of stare decisis required an assessment of the strength of the grounds on which Roe was based. We therefore turn to the question that the Casey plurality did not consider, and we address that question in 3 steps. First, we explain the standard that our cases have used in determining whether the 14th Amendment's reference to, quote, liberty protects a particular right. Second, we examine whether the right at issue in this case is rooted in our nation's history and tradition, and whether it is an essential component of what we have described as, quote, ordered liberty. Finally, we consider whether a right to obtain an abortion is supported by other precedents. And you'll see that they don't agree. Constitutional analysis must begin with, quote, the language of the instrument. This is from Gibbons v. Ogden in 1824. I mean, we're going all the way back to the beginning of the United States, right after the Constitution was written. Granted, the Constitution was written in, I believe it was 1789, and this is an 1824 case, but pretty close if you think about it. That's only about, 40 years from the time that we actually became a nation. In this case, offers a fixed standard for ascertaining what our founding document means. The Constitution makes no express reference to a right to obtain an abortion, and therefore those who claim that it protects such a right must show that the right is somehow implicit in the constitutional text. Roe, however, was remarkably loose in its treatment of the constitutional text. It held that the abortion right, which is not mentioned in the Constitution, is a part of a right to privacy, which is also not mentioned in the Constitution. And that privacy right, Roe observed, had been found to spring from no fewer than 5 different constitutional provisions: the 1st, 4th, 5th, 9th, and 14th. And I might add that they don't mention the 10th, which is probably the most critical amendment from which this Roe should have been decided 50 years ago. But it's not mentioned because they would have lost under the 10th Amendment argument. The court's decision in Roe left open at least 3 ways in which some combination of these provisions could protect the abortion right. One possibility was that the right was founded in the 9th Amendment's reservation of rights to the people. Another was that the right was rooted in the 1st, 4th, and 5th Amendment, or in some combination of those provisions, and that this right had been incorporated into the Due Process Clause of the 14th Amendment, just as many other Bill of Rights provisions had by then been incorporated. And the third path was that the 1st, 4th, and 5th Amendments played no role, and that the right was simply a component of the liberty protected by the 14th Amendment's Due Process Clause. Roe expressed the, quote, feeling that the 14th Amendment was the provision that did the work, but its message seemed to be that the abortion right could be found somewhere in the Constitution, and that specifying its exact location was not of particular importance. The Casey Court, that's the 2007 case we referenced earlier, did not defend this unfocused analysis and instead grounded its decision solely on the theory that the right to obtain an abortion is a part of the, quote, liberty protected by the 14th Amendment's Due Process Clause. And as you probably know, the 14th Amendment is a really short amendment. It was an amendment, it wasn't a part of the Bill of Rights, which is the first 10 amendments, but it was an amendment made that basically protected due process rights to individuals. So it was really a stretch to make this work. And it was, again, Roe came out during a very liberal time in our history, during the Vietnam War, when there was a lot of social unrest, when women's rights were, spearheaded, for women to have more rights than men. And I've never been particularly, even at that time, and I was alive at that time, I never even thought at that point women's rights was really that important. I thought it was kind of silly when I watched all these people march around when the Mary Tyler Moore show was on, and I guess Rhoda wasn't out at that point, but it was when I guess Norman Lear and Spelling had all these new sitcoms coming out that were extremely liberal, like Sanford and Son and what have you. I just remember being a really liberal, almost silly time in our history from the vantage point of an 11-year-old. But anyway, even as 11, I thought it was all kind of just silly, and I just wanted to get on with it. So the Supreme Court says we discussed this theory in depth using the 14th Amendment as the process to get to show that Roe made abortion rights as adhered by the different state laws unconstitutional. And we briefly, the Supreme Court, addressed one additional constitutional provision that some of the respondents' amici have now offered as yet another potential home for the abortion right, the 14th Amendment's Equal Protection Clause. Now, neither Roe nor Casey saw fit to invoke this theory, and it is squarely focused by our precedents, which established that a state's regulation of abortion is not a sex-based classification and is thus not subject to the heightened scrutiny that applies to such classifications. The regulation of a medical procedure that only one sex can undergo does not trigger heightened constitutional scrutiny unless the regulation is a mere pretext designed to effect an invidious discrimination against members of one sex or another. And, as the court has stated, the goal of preventing abortion does not constitute an invidiously discriminatory animus against women. And they're quoting a case from 1993. Accordingly, the laws regulating or prohibiting abortion are not subject to heightened scrutiny, and that's how you would get it into the constitutional purview for the Supreme Court to be able to view it, whether it's constitutional or not, determining on whether or not what scrutiny it reaches. Rather, they are governed by the same standard of review as other health and safety measures. And that's going to be discussed a little bit later on in the opinion. Hopefully we'll get to that today, and we should, because it's the last part of this particular issue that we're covering. With this new theory addressed, we turn to Casey's bold assertion that abortion right is an aspect of the, quote, liberty protected by the Due Process Clause. Now, the underlying theory on which this argument rests, the 14th Amendment's Due Process Clause, provides substantive as well as procedural protection for, quote, liberty, and has long been controversial. But our decisions have held that the Due Process Clause protects two categories of substantive rights. The first consists of rights guaranteed by the first 8 amendments. Those amendments originally applied only to the federal government. But this court has held that the Due Process Clause of the 14th Amendment incorporates the great majority of those rights and thus makes them equally applicable to states. So if you go read the first 8 amendments to the Constitution, they all are geared toward the rights of individuals as against the government's authority and autonomy, because the government was still acting as Big Brother. And our founding fathers, were trying to protect the citizens from the very thing that they were running away from when they came to the United States. And they were also running away from, religious persecution, which is a constitutional issue that we have the rights to determine our religion. But it was also economically difficult in that period in Europe. So many people were coming over and looking for a way out. And here we had all this land. And remember, when we came over to the United States, we shoved the Indians out of their homes. So I don't know if the people that came over and the founding fathers were really morally any more or less corrupt than the people they were running from. But we're established, and it's worked out the way it is. There's nothing we can do about the past. There's no reparations going to the Indians or anybody else. It is what it is. And what we ended up with was a really well-written Constitution that was, in my opinion, akin to the Magna Carta in the way that we can follow it. And it's worked so far and is probably the best written rules that we live by in the world, which makes us, I think that's what makes our country the country that people flee to be able to have a an enjoyable life of freedom to the extent that it's better than what is offered by other countries. Now, the second category, which is one question here, comprises a select list of fundamental rights that are not mentioned anywhere in the Constitution. In deciding whether a right falls into either of these categories, the court has long asked whether the right is, quote, deeply rooted in our history and tradition, and whether it is essential for our nation's scheme of ordered liberty. Remember, these were written by the forefathers to be different and to have a better organizational setup in life and governing rules than they had in England, France, Italy, where they had fiefdoms and, and the type of things that you learned about in elementary school and in your secondary education, why people were leaving Europe and getting on ships and trying to find a place to live, not just for economic commerce and pirating and finding gold and what have you, but really trying to find a place where they could live at peace without Big Brother looking over them. Okay? So that was first 8 amendments. Actually, first 10 amendments, but they really focused on the first 8 here with regard to what they were talking about in the previous paragraph. And in conducting this inquiry, we have engaged in a careful analysis of the history of that right at issue. Justice Ginsburg's opinion in the court in Tibbs versus Indiana is a recent example in concluding that the 8th Amendment's protection against excessive fines is fundamental to our scheme and ordered liberty and deeply rooted in the nation's history and tradition. All right. She goes on to say that, or they go on to say, a similar inquiry was undertaken in McDonald, which was the case, which held that the 14th Amendment protects the right to keep and bear arms, a big issue right now. The lead opinion surveyed the origins of the Second Amendment, right to bear arms, the debates in Congress about the adoption of the 14th Amendment, and the state constitution in effect when that amendment was ratified. So the climate of what was going on at the time that it came about. Let's see. Only then did the opinion conclude that the framers and the ratifiers of the 14th Amendment counted the right to keep and bear arms among those fundamental rights necessary to our system of ordered liberty. This is huge right now because of the Uvalde issue and people saying that we need to, have more gun control and what have you. It all goes back to whether or not this is even a federal issue. In my opinion, it's a state's issue because the federal Constitution, the United States Constitution, has already given us the right to bear arms. With our open border right now, with us not knowing who is coming over, with us already having admitted terrorists telling us that they have aligned and scheduled for terrorists to come over to assassinate a prior president. I mean, that was just in the paper and verified by the State Department last week. It's probably correct that we still have the right to bear arms here in Texas because we're so close to what is akin to an open border. We're not protecting it. People are coming over, and we don't know who might, like in the instance of the Ukrainians, we don't know who might come over, such as Putin, or, maybe the Mexicans have, I'm not saying they have, but it would be no different from what Russia's doing right now with the Ukraine. Russia believed that the Ukraine should always have been a part of them. Mexico could well say for hundreds of years before the Pilgrims came over, the United States came over, there was a Constitution made, the United States should have been at least part of it, a part of Mexico, and they were going to take it back. I mean, with the right to bear arms, we can at least protect ourselves like the Ukrainians are now. But different show altogether. Okay, so Tibbs versus McDonald. Tibbs and McDonald concern the question as to whether the 14th Amendment protects rights that are expressly set out in the Bill of Rights and would be anomalous. What word is that? I'm sorry, I went to law school and I have a decent vocabulary, but I don't know what that is. Anomalous, I guess, similar. Anomalous if similar historical support were not required when a putative right is not mentioned anywhere in the Constitution. Thus, in Glucksberg, which held that the Due Process Clause does not confer a right to assisted suicide, the court surveyed more than 700 years of Anglo-American common law tradition. We're talking way before the United States, and made clear that a fundamental right must be objectively and deeply rooted in this nation's history and tradition before it will be, a right will be conferred upon it by the Constitution and its review. And that would be whether or not it would depend on the level of scrutiny. And there's 3 levels, and you learn that in your constitutional law classes in law school and what have you. But it has to be raised to a very high level before it's scrutinized by the Supreme Court as to whether it's constitutional or not. Historical inquiries of this nature are essential whenever we are asked to recognize a new component of liberty protected by the Due Process Clause, because the term liberty alone provides little guidance. Liberty is a capacious, another word I'm going to new vocabulary, capacious term. And my husband would kill me because he's got a much higher vocabulary than me, and he's probably rolling his eyes right now if he's listening. As Lincoln once said, we all declare for liberty, but in using the same word, we do not all mean the same thing. In a well-known essay, Isaiah Berlin reported that historians of ideas had cataloged more than 200 different senses in which the term liberty had been used. In interpreting what is meant by the 14th Amendment's reference to liberty, we must guard against the natural human tendency to confuse what that amendment protects with our own ardent views about the liberty that Americans should enjoy. That is why the court has long been reluctant to recognize rights that are not mentioned in the Constitution. And I love the namesake, but here it is. Collins versus Harker Heights is a 1992 U.S. Supreme Court opinion that quotes exactly that. Substantive due process has at times been a treacherous field for this court, the Supreme Court, and has sometimes led the court to usurp authority that the Constitution entrusts to the people's elected representatives, I guess on a state or federal level, but not to the judiciary, not to that branch of the government, but to the legislative branch of the government. As the court cautioned in Glucksburg, we must exercise the utmost care whenever we are asked to break new ground in this field, lest the liberty protected by the Due Process Clause be subtly transformed into the policy preferences of the members of the court at the time that a case is being heard. On occasion, when the court has ignored the appropriate limits imposed by respect for the teachings of history, it has fallen into the freewheeling judicial policymaking that characterize discredited decisions such as Lochner v. New York, which is a 1905 case. And I wonder what that one was about, because I don't know why they're saying that was a bad decision, but that's what they're implying. The court must not fall prey to such an unprincipled approach. Instead, guided by the history and tradition that map the essential components of our nation's concept of ordered liberty, we must ask what the 14th Amendment means by the term liberty. When we engage in that inquiry in the present case, the clear answer is that the 14th Amendment does not protect the right to an abortion. And that's what they did. It was legal gymnastics in Roe v. Wade 50 years ago for the end to meet the means, or the means to meet the end, or however that saying is. In other words, it wasn't the Supreme Court's authority, and they didn't have a well-reasoned or even a reasoned opinion to assert that the 14th Amendment would make a state law brought about by the legislature of each state unconstitutional because it wasn't unconstitutional based on the very reasoning that they used to overturn it. So it's just legal gymnastics. If the 10th Amendment had been addressed, it would have gone back to the states. And as you will see, the Supreme Court is saying that the states, each state has the right to make the law through the legislature, through the people, through their own decisions to determine what laws that they want to rule with regard to abortion. It's just not a federal issue, and it's not a right that's guaranteed through the Constitution through the Constitution, either expressly or through a right that has been brought into the Constitution through the amendments or the base of the Constitution. Now, until the latter part of the 20th century, there was no support in the American law for a constitutional right to obtain an abortion. Zero. None. No state constitution provision had recognized such a right. Until a few years ago, before Roe was handed down, and that few years ago, that's like 50 years ago, no federal or state court had recognized such a right, nor had any scholarly treatise of which we are aware. And although law review articles are not reticent about advocating new rights, the earliest article proposing a constitutional right to abortion that has come to our attention was published only a few years before Roe. That would be in the 1960s. So not only was there no support for a constitutional right until shortly before Roe, therefore no stare decisis, which was a big issue that was our element that was relied upon in Casey and Roe incorrectly. But abortion had long been a crime in every single state through the legislated law. A common law abortion was criminal in at least some stages of pregnancy and was regarded as unlawful and could have very serious consequences at all stages of a pregnancy. American law followed the common law until a wave of statutory restrictions in the 1800s expanded the criminal liability for abortions, not reduced it. By the time of the adoption of the 14th Amendment, 3/4 of the states had made abortion a crime at any stage of pregnancy, and remaining states would soon follow. Roe either ignored or misstated this history, and Casey declined to reconsider Roe's faulty historical analysis. It is therefore important now to set the record straight. We begin with the common law under which abortion was a crime, at least after quickening, the first felt movement of the fetus in the womb, which usually occurs between the 16th and the 18th week of pregnancy. And the exact meaning of quickening is subject to some debate. And this is in a footnote of the case. It is meant, a quick child meant simply a live child, and in the era's outdated knowledge of embryology, a fetus was thought to become quick at around the 6th week of pregnancy. That's pretty early, even for back then. We need not wade into this debate. First, it suffices for the present purposes to show that abortion was criminal by at least the 16th or 18th week in pregnancy. Second, as we will show, during the relevant period, the period surrounding the enactment of the 14th Amendment, the quickening distinction was abandoned as states criminalized abortions at all stages of pregnancy, including prior to quickening. Now, the eminent common law authorities all describe abortion after quickening as criminal. Henry de Bracton's 13th century treatise explained that if a person has, quote, struck a pregnant woman or has given her poison whereby he has caused an abortion, if the fetus be already formed and animated, and particularly if it be animated, he commits homicide. This is all the way back to the 13th century. That's 1200, around the time of the Magna Carta. Sir Edward Coke's 17th century treatise likewise asserts that abortion of a quick child was murder. If the child be born alive and a great misprision, if the child's death in her body, all these words are spelt really funny because they're quoting a 17th century treatise. Two treatises by Sir Matthew Hale likewise describe abortion as a quick child who died in the womb as a great crime and a great misprision. And writings near the time of the adoption of our Constitution, Blackstone explained that abortion of a quick child was, quote, by ancient law, homicide or manslaughter, and at least a very heinous misdemeanor. English cases dating all the way back to the 13th century corroborate the treatise's statements that abortion was a crime. In 1732, for an example, Eleanor Baer was convicted of destroying the fetus in the womb of another woman and, quote, thereby causing her to miscarry. For that crime and another misdemeanor, Baer was sentenced to 2 days in the pillory and 3 years imprisonment. Although a pre-quickening abortion, and that would be the ones that I believe even now in Texas, because our laws allow an abortion before the 6th week, even a pre-quickening abortion was not itself considered homicide. Although, a pre-quickening abortion was not in itself considered a homicide, it does not follow that abortion was permissible at common law at any time, much less that the abortion was legal or a legal right. And basically, they're saying that an abortion prior to the 6th week may not have may not have been permissible even at that time, but much less than abortion. It wasn't a legal right either, so it was kind of kept quiet and not discussed. And I don't know. We didn't live during those times, so it's hard to say what exactly the repercussions were for an abortion at any time. But I suspected that if no one knew about it, no harm, no foul. Removal of common law's harsh sanctions did not represent an acceptance of this says of a suicide, but it wouldn't be a suicide if the baby was born, but or was aborted. Quite to the contrary, in the 1732 case mentioned above, the judge said that the charge of abortion, with no mention of quickening, he had, quote, never met with a case so barbarous and unnatural. Similarly, an indictment from 1602, we're going even further back, which did not distinguish between pre-quickening and post-quickening abortion, described abortion as pernicious and against the peace of Our Lady of the Queen, her crown and dignity. The common law did not condone even pre-quickening abortions, and by the way, one might call a proto-felony murder rule. Hale and Blackstone explained it in a way in which a pre-quickening abortion could rise to the level of a homicide. Hale wrote that if a physician gave a woman with a child a potion to cause an abortion, and that woman died, it was murder because the potion was given unlawfully to destroy her child within. As Blackstone explained, to be murder, a killing had to be done with the malice aforethought, either express or implied. Blackstone wrote that the law will imply malice for the same reason that it would imply malice if a person who intended to kill a person accidentally killed a different person. And this is the law on that. I've always thought this was kind of an interesting concept in law about malice aforethought, because I've done murder trials and what have you, but this is still the rule. This is the logic. It goes all the way back. This is where we get our reasoning from, and it is well settled. If one person shoots A, for an example, if I shoot station manager Dick and miss him, but I kill B, let's say he has a person that's in the room behind him and I accidentally goes to the wall and kills him, this is a murder. That means that I didn't mean to kill the person in the other room, but it's still murder based on this well-settled reasoning. Because the previous felonious intent, because I was trying to shoot and murder station manager Dick, which the law transfers from one to the other. The same is the case where one lays poison for A and B, against when the prisoner had no malicious intent, takes it, and it kills him, and is likewise murder. So, also, if one gives a woman with a child a medicine to procure an abortion, and it operates so violently as to kill the woman, this is murder in the person who gave it, even if it was an accident because it was just for an abortion. So, this was all under very, very done very quietly, because if the woman dies because the doctor gave her medicine for an abortion, or anybody gave her an abortion, then that's still murder, even if it was just to help her with something that she wanted. Notably, Blackstone, like Hale, did not state that this proto-felony murder rule required that the woman be with quick child, only that she be with child. And it's revealing that Hale and Blackstone treated abortionists differently from other physicians or surgeons who caused the death of a patient without any intent of doing the patient any bodily harm. These other physicians, even if unlicensed, would not be guilty of murder or manslaughter, but a physician performing an abortion would, precisely because of his aim was an unlawful one, would be charged with murder. In sum, although common law authorities differed on the severity of the punishment for abortions committed at different points in the pregnancy, none endorsed the practice. Moreover, we are aware of no common law case or authority, and the parties have not pointed to any, in this particular case, Dobbs v. Jackson's Women's Health Organization, that remotely suggest that a positive right to procure an abortion at any stage of pregnancy is legal. In this country, the historical record is similar. The most important early American edition of Blackstone's commentaries report Blackstone's statement that abortion of a quick child was at least a heinous misdemeanor. And that was written in 1803. So Blackstone was, back in the times of our founding fathers. Let's see. It says few cases available from the early colonial period corroborate that abortion was a crime. So that's kind of interesting. It says here it says few cases available from that history corroborate that abortion was a crime, but nothing corroborates that it wasn't a crime. This one goes on to give an example that in Maryland in 1652, way before the colonial period, because in 1492 they sailed the ocean blue. I guess the Mayflower came out in 1492. And when did we start? We come over and the James Colony was settled. I'm going to say it was in the 1600s. This is probably about then in Maryland. In Maryland in 1652. I wish I could remember my early American history. I need to kind of hone up on that. But anyway, early on, before our Constitution, we were still under British authority in 1652 in Maryland. An indictment charged that a man murderously endeavored to destroy or murder the child by him begotten in the womb, in a case that they are referencing. It says, by the 19th century, courts frequently explained that common law made abortion of a quick child a crime. The original ground for drawing distinction between pre- and post-quickening abortions is not entirely clear, but some have attributed the rule to the difficulty of proving that a pre-quickened fetus was even alive. At that time, there was no scientific methods for determining pregnancy in early stages, and thus, as one court put it in 1872, until the period of quickening there is no evidence of life, and whatever may be said of the fetus, the law has fixed upon this period of gestation as a time when a child is endowed with life, because fetal movements are first clearly marked and well-defined evidence of life. And so this is well before we had scientific evidence that a child could even survive outside the womb. So this is the reasoning that life exists because there is some evidence that it exists. In contemplation of the law, life commences at the moment of quickening and at the moment when the embryo gives the first physical proof of life, no matter when it first received it. So when the soul, which is, a whole different argument of when a person, when life begins. Is it upon conception? is it begun at quickening? Is it when the with the first heartbeat, when the baby breathes its first breath? I mean, there's a lot of arguments about that. But this Justice Alito is not trying to go to the scientific evidence of when a child is viable or has life. He's simply looking at the scrutiny through the constitutional viability on whether it's constitutional or not, and has reasoned that it is not a constitutional issue that should be that rises to the level of the height of scrutiny that the Supreme Court should be reviewing it, much less find that it is unconstitutional when it's not referenced in the Constitution, and should be something that be taken up on a state level because it's not within the purview of the federal government. Now, the Solicitor General of the United States offers a different explanation of the basis for quickening rule, namely that before quickening, the common law did not regard a fetus as having a separate and independent existence. Brief for the United States amicus in 1848 in the Commonwealth versus Parker is what they were quoting there. But the case on which the Solicitor General relies for this proposition also suggested that the criminal law's quickening rule was out of step with the treatment of the prenatal life in other areas of law, noting that too many purposes reference civil rights. An infant in venture sa mirror is regarded as a person in being. At any rate, the original ground for the quickening rule is of little importance for the present purposes because the rule was abandoned in the 19th century, 1800s. During that period, treatise writers and commentators criticized the quickening distinction as, quote, neither in accordance with the result of the medical experience nor with the principles of common law. In 1803, the British Parliament made abortion a crime at all stages of pregnancy and authorized the imposition of severe punishment. You know, England's pretty liberal. I mean, they're the ones that got rid of the Catholic Church and went all Episcopals. They get divorces and, you know, and various other things. So even they were saying that abortion is a crime. One scholar has suggested that the Parliament's decision may partly have been attributable to the medical man's concern that fetal life should be protected by the law at all stages of gestation. In this country during the 19th century, the vast majority of the states enacted statutes criminalizing abortion at all stages of pregnancy. By 1868, when the 14th Amendment was ratified, that's when this was, you know, almost 100 years after we became, almost 100 years before we became a nation. We won our independence, and almost 100 years from when the Constitution was written. By 1868, when the 14th Amendment was ratified, 3/4 of the states, that's 28 out of 37 that were in place at that time, had enacted statutes making abortion a crime, even if it was performed before quickening. Of the 9 states that had not yet criminalized abortion at all stages, all but one did so by 1910. Therefore, there was no stare decisis. The state legislature had determined that abortion was a crime at all stages. And this was at the point that the 14th Amendment was enacted. So clearly the 14th Amendment couldn't have been written for the purpose of availing the right of a private protection for abortion when all the states, almost all the states at that time, and later all the states by 1910, had made it a crime in all phases. So the trend in the territories that would become the last 13 states was similar. All of them criminalized abortion at all stages of pregnancy between 1850 and 1919, New Mexico. 1850, the Kingdom of Hawaii, and 1919, New Mexico. By the end of the 1950s, according to the Rose Court own account, statutes in all but 4 states and the District of Columbia prohibited abortion, however, and whenever performed, unless done to save and preserve the life of the mother. So Roe could never have legally and logically relied upon stare decisis or even the 14th Amendment to rule that abortion laws in Texas were unconstitutional, but they did. And somehow it was maintained as the law until this one, which has not been issued yet, but probably will be issued, will rule that the abortion laws in Mississippi are constitutional, and therefore the laws in Texas will likewise be constitutional. The overwhelming consensus endured until the day Roe was decided. This was the overwhelming consensus. At the time, also, that the Roe court's own court, a substantial majority, 30 states, still prohibited abortion at all stages except to save the life of the mother. And though Roe discerned a trend toward liberalization, which they were really liberal, as we discussed earlier, in about 1/3 of the states, those states still criminalized some abortions and regulated them more stringently than Roe would allow. In short, the court's opinion in Roe itself convincingly refutes the notion that the abortion of liberty is deeply rooted in the history of the tradition of our people. So again, Roe used legal gymnastics to get to an end that they wanted. And as we went over in the last segment of our show, the women that argued Roe were really just looking for a topic to make a stand on. They weren't abortion rights advocates. The one woman, one of the attorneys who was 26, had gone to Mexico for an abortion, but did not even try to help Norma McCorvey, who was the Jane Roe, who wanted an abortion, get one, because she just wanted somebody that she could use to make a case. She wasn't working for a big law firm. She couldn't get hired. She graduated from University of Texas. She was a colleague of many of the up-and-coming women attorneys of that day. She only died recently. She was only 26. She'd never tried a case. So she was just trying to get her foot in the door, and this was her, cause du jour. And they really shouldn't even have had standing, to be honest with you, because the baby had already been born, with this was already being argued, and they were arguing whether the abortion rights were valid or not. And had they really wanted to help her, they could have gone to other states to help her. And she was early enough along, I believe, to have even satisfied Texas state laws at that time. But they didn't want to help her. They just wanted a case. So the inescapable conclusion is the right to abortion is not deeply rooted in this nation's history and traditions. On the contrary, an unbroken tradition of prohibiting abortion on the pain of criminal punishment persisted from the earliest days of the common law until 1973. The court in Roe could have said of abortion exactly what the Glucksburg court said of assisted suicide. Quote, attitudes toward abortion, and they put that in quotes, have changed since Bracton, but our laws have consistently condemned and continued to prohibit that practice. Respondents and their amici have no persuasive answer to this historical evidence. Neither respondents nor the Solicitor General disputes the fact that by 1868, the vast majority of states criminalized abortions at all stages of the pregnancy. Instead, respondents are forced to argue that it, quote, does not matter that some states prohibited abortion at the time Roe was decided or when the 14th Amendment was adopted. But that argument flies in the face of the standard that we have applied in determining whether an asserted right that is now nowhere mentioned in the Constitution is nevertheless protected by the 14th Amendment, completely ignoring the 10th Amendment that would have given the rights to the states to look at this, and that it should have gone through the states, through their legislature, and not through that state's constitution, unless that state's constitution addressed that specifically, or privacy rights specifically. Not only are respondents and their amici unable to show that a constitutional right to abortion was established when the 14th Amendment was adopted, but they have found no support for the existence of an abortion right that predates the latter part of the 20th century. No state constitution provision, no statute, no judicial decision, no learned treatise. The earliest sources called to our attention are a few district court and state court decisions decided shortly before Roe in 1973, and a small number of law review articles that are from that same period. I wrote law review articles, and they're simply scholarly articles written by law students or law professors or attorneys that are stating their case about a particular situation. They're not law, they're opinion. So, and yes, they're supported by law, but when my law review article won all kinds of awards in what have you. And when I wrote it for a case, for a particular assignment while I was on law review, and my heart was in it because it was what I chose to write about, but I wasn't trying to make a case. I was simply arguing the law that supported one side of facts and the law that supported another side of facts, and kind of throwing out there what the way it could be viewed a different way. So it was just an opinion. That's what law review articles are. And even amici briefs are the same way. They are opinion until the court decides it. But the Supreme Court can only take a case if it meets the heightened scrutiny. And, there's various reasons why the Supreme Court would take a case. But in this particular case, they were arguing that a state law was unconstitutional. And this particular Justice Alito, is saying that there is just no basis in the Constitution to find that the Texas law at the time was unconstitutional, and Roe was decided improperly. Now, a few of the respondent amici muster historical arguments, but they are still very weak. The Solicitor General repeats Roe's claim that it is doubtful abortion was ever firmly established as a common law crime, even with respect to the destruction of a quick fetus. But as we have seen here, great common law authorities like Bracton, Cole, Hale, and Blackstone all wrote that a post-quickening abortion was a crime, and a serious one at that. Moreover, Hale and Blackstone asserted that even a pre-quickening abortion was unlawful, and that as a result, an abortionist was guilty of murder, and if the woman died from the attempt. Instead of following those authorities, Roe relied largely on two articles by pro-abortion advocate who claimed that Koch had intentionally misstated the common law because of his strong anti-abortion views. These articles have been discredited, and it has come to the light that even the members of Jane Roe's legal team did not regard them as serious scholarship. An intentional memorandum characterizes this author's work as dunning, quote, the guise of impartial scholarship while advancing the proper ideological goals. Continued reliance on such scholarship is unsupportable. The Solicitor General next suggests that the history supports an abortion right because of the common law's failure to criminalize abortion before quitting means that it could terminate it practically, at least in the early stages. But the insistence on quickening was not universal, and regardless, the fact that many states in the late 18th and 19th century did not criminalize pre-quickening abortion does not mean that anyone thought the states lacked the authority to do so. When legislatures began to exercise that authority as the century wore on, no one, as far as we are aware, argued that the laws that they enacted violated any fundamental right, and that would be the right to find that make a law that criminalized abortion at any stage. That is not surprising, since common law authorities had repeatedly condemned abortion and described it as unlawful act without regard to whether it occurred before or after quickening. Another amicus brief relied upon the respondents to try to dismiss the significance of the state criminal statutes that were in effect when the 14th Amendment was adopted by suggesting that they were enacted for illegitimate reasons. According to this account, which is based almost entirely on statements made by one prominent proponent, important motives for the laws were the fear that Catholic immigrants were having more babies than Protestants, and that the availability of abortion was leading white Protestant women to shirk their maternal duties. So anyway, resorting to this argument is a testament to the lack of any real historical support for the Roe and Casey decisions. And, without going into, again, more and more detail of this case, it was a very long and well-written case. It was overturned because there was simply no constitutional basis for Roe, and the states have the authority to decide, and it's up to the states to decide under the 10th Amendment. It looks like we may have a part 5 on this if I keep reading it, because it's just so entirely interesting. And Justice Alito wrote such an amazing opinion on it. So we're going to conclude with that part of it today of the Roe versus Wade segment. This is Legal Connection Show. Remember, the most important thing you can do for the next week before you tune in again next week or visit some of our past shows to listen to this is to serve God by serving others. And we will see you again next week.